Yes. Let's first take a moment to pause. And again, in the chat, if you would care to share with me why you're coming here today. What is it that has you thinking this is something I need to address? Is it your family? Is it your little ones? Is it your parents who are getting a bit older? Is it your own peace of mind, your own self-care that you're looking to address these questions that have been lingering for you for a long time? Or are you just here to get education? All of those are good reasons to be here. And I really am so pleased that you're here and really want to encourage you to honor your own reasons for being here and really keep them forefront of mind while you're here. Again, if you need the worksheet, this QR code will take you to the worksheet in a Google form, which will be sent to you directly after the presentation. Well, as soon as you click submit, and it'll just help you keep track of the key takeaways from this presentation. All righty. So first, before we dive into it, let me address some common myths about estate planning. It's actually very rarely spoken, but almost always present. There is a fear that planning will hasten death's occurrence. I can say that that didn't happen for me, and nor has it happened for any of my clients. And while I can share that I'm not sure if there is fate, I will also share that I've never heard anybody say that it was a mistake to plan for their family's security. Better safe than sorry, right? The second myth that comes up again almost every time is you don't need to plan if you don't have money. And as I just shared before, that's actually kind of the polar opposite. I would really argue that those without a ton of money are the ones most in need of a good plan because you don't have the flexibility that the wealthy have in terms of other available resources. In addition to which, this isn't really about money. This is about choice. So many of the decisions that you make in estate planning have nothing to do with your money. They have a lot to do with putting the right people in place at the right time to be able to make the right decisions for your family and for you to be able to guide them in how you would want that to happen. This is about choice. The third myth that comes up a lot is that I don't have the money to pay for an attorney to do this. And I would say you probably need to flip that one too. In fact, as I mentioned before, estate planning really is an investment and it does yield positive rewards, and you will likely spend far more doing nothing and relying on the state's default plan than you would in drafting an estate plan or hiring an attorney to draft an estate plan. So on that note, I actually would love to share with you I ran these numbers, speaking of cost. So the average Californian owning a home, so the average California home value is $742,352. So if you own a home, you're on one side or another of that. The average cost of a trust in our state is about $4,000. So with that $4,000, you could potentially be saving your family $33,000 in the costs of probate, because I hate to tell you this, a California home is an enormous risk to have without an estate plan, both because of cost and because of the potential disputes that could arise after your death if you haven't addressed the question of who inherits. So I encourage you to think of estate planning as an investment with returns rather than a cost that you can't afford, because frankly, I think nobody can afford probate. And with a properly drafted estate plan, you can avoid probate entirely. So we're looking at about a 9 times return on investment for the average California home. All righty. And then one last thing I should mention is that while all of this money stuff does benefit your family, you're not around anymore to receive the benefits of that cost savings. It gives you peace of mind to know that all of the things that you took care of now are things that you don't have to worry your family with when they're grieving your loss. All righty, so let's cover really quickly what we're going to learn today. What you'll learn today is we're going to cover all of the basic documents of an estate plan. That includes a will, that includes for most people a trust, but there's a lot of other documents in the constellation of an estate plan. And I think it's really important for you to understand the breadth of what a fully planned out estate plan is. We're also going to talk a lot about the state's plan for you, and I'm going to intersperse this throughout the presentation. The state has a default plan for everybody who dies intestate, which means without a will. And it's not great. It involves a lot of things that I can almost guarantee you don't want your family to go through. We'll also cover whether you need an attorney's help. You might not need an attorney's help. You might not need to meet with me. And I will give you some free resources if you fall in that category so you can complete your estate plan yourself. And then finally, we'll talk about what I do, which is a little bit different. I do something called life and legacy planning, which is it's estate planning plus, I would say. There's a lot of non-legal stuff that goes into the way that I run my estate planning firm that makes it less about planning for death and more about planning for life. And I'll share that with you too at the end of the presentation. Alrighty, so let's dig in. First, the basics. As I mentioned, every state in our union has a default plan for all of their residents who die without a will. California's plan is the one I'm going to be speaking about today. I believe all of us are California residents. I only practice in California, so if you live in another jurisdiction, I'm happy to provide a referral. The state's plan for you could involve the police or child custody, taking custody of your children, or child protective services, taking custody of your children upon you simply not being able to show up at the place you're expected. Without the proper documentation in place for another person to take custody, they could end up in a system that you do not want them in. Other things that could happen, your family will likely end up in court. Without a will, they will definitely end up in court. With a will and some other problems, they could end up in court. In addition to which, a lot of your assets will go missing if you don't have an estate plan, which a big part of is actually just inventorying what you have in a single location so that everybody who survives you knows where to find it. So often this very essential component is missing and a lot of assets just disappear. And let me tell you, they disappear to the state. They go to the state's Department of Unclaimed Property, which in California is currently sitting at around, I think, $12 billion in assets. So definitely don't want to be adding to that. Finally, if you do have an estate plan, but it hasn't been reviewed in more than 3 years, you're defaulting back to the state's plan. In all likelihood, an estate plan that hasn't been reviewed in 3 years or more is probably out of date, either due to life circumstance or the law, in which case, when there is a question or there is conflict, the state's default comes in. So next, estate planning, let's just talk about what it is. So as I mentioned, it's a lot more, but it certainly includes financial planning. And done well, it's financial planning for life and not just for after your death. It's also guardianship planning. Who do your kids go to when you aren't able to take care of them? It's tax planning, trying to make sure that when that turnover happens, when your heirs inherit, they are paying and your estate is paying the least amount of taxes possible. It's long-term care planning. You are designating people to take care of you when you aren't able to make decisions for yourself. And it's also business planning, which we're not going to cover today, but is a major part of my work as I work with business owners to help them design plans for what would happen when the business owner becomes unavailable or dies. And so there's so much that's involved in estate planning. It's not just where does my money go? It's really the process of making sure that you don't leave a mess for your family. All righty. So let's talk about the average Jane, the average John. On their plate in an adult capacity is probably their health, their business or professional practice or profession or job or whatever, your home and your stuff, your family, and your finances. And while you're juggling all of that, and you're doing a great job while you're alive, well, an estate plan is there to catch all of that when you aren't there anymore. You become incapacitated, meaning you aren't able to make decisions. Either it can be an emotional incapacity, it could be a mental incapacity, it could be a physical incapacity, it could be a vegetative state. There's a lot of range within the concept of incapacity. And when it's essentially when you are not able to be there anymore to take care of your basic responsibilities, either because of incapacity or death, an estate plan comes in to provide that safety net for your family and all of your things. So the basic components of an estate plan are these. Your health is cared for while you're alive but incapacitated by an advance healthcare directive. I would also mention that includes a release form under HIPAA, which is the medical records federal law. That allows the persons you designate to make medical decisions for you to actually access your medical information and your records with which to make the decisions. So those two together comprise the planning for your health. I'm going to skip to finances in the lower right corner. A durable power of attorney is how you designate somebody to take care of your finances once you become incapacitated. This is not after you die. That's a will that takes care of that after you die. This is the period when you are still alive but aren't able to make decisions for yourself. Then going up the screen to the right is the guardianship plan. This is well, it's actually several documents that comprise a plan for your minor children in the case that you are not able to care for them. This includes the legal documents of this is the person I want to name as a guardian. And it also can include other things like instructions to your guardians or information for your children about what lessons you'd like to pass on to them. That can be quite a fulsome package. Turning down around to the bottom is the will and the trust. Now, this is not really an either or situation. You want a will in every case. But for certain people, a lot of people, you are also going to want a trust. And we're going to talk about why. We're going to talk about the benefits of a trust. And we're going to talk about who really needs one. And the one I'm not going to cover today is the business succession plan, but I will have a special seminar on that for those of you who are business owners or professional practice owners. So stay tuned for that. Okay, so the Chens are going to help me illustrate for you some really, really, really typical consequences of not planning. All right, so the Chens are a family of 5. We have mom and dad, Mark and Molly, and the children, Alex, Ben, and Caroline. It's a blended family. Molly's previous partner, Dan, is the father of their child, Alexander. And this family has about $1 million in assets, and with combining their life insurance, cash on hand, and retirement savings. This is fairly standard in the state of California, and they also own a home. You'll hear so often how home ownership really impacts whether you need a trust. So we're going to follow up on that. Okay, so 1 year on the family vacation, something happens. There's an accident. Mark is injured and Molly is incapacitated. Now, Mark and Molly are not married. This is a big part of California's default, is spouse's control. But if you're not married, your partner will not have the ability, because they're not related to you, to make medical decisions in your stead. So that's where an advanced healthcare directive and HIPAA release step in. All right. Without an advanced healthcare directive, you're stuck with the default decision makers. They are, in California, your spouse, your adult children, and then your parents. If you don't have any of those living, really anybody can step in and petition to be your healthcare agent in that time. And that is not a situation that you want, or the hospital's making decisions for you. Also not a decision you want. Default decisions are also a risk. The default decisions often will follow the hospital's policy to avoid malpractice, which means primarily keeping you alive, whether or not that's what you would have wanted. And in addition, your family may have to go to court if they know your wishes conflict with what's happening. A really sad example of that, for those of you who may remember, Terri Schiavo was a woman in, I want to say Texas or Florida, I can't remember, I'm sorry, who was the subject of a lot of cases, a lot of litigation between her parents and her husband about how her personhood should be handled when she was in a vegetative state. Her parents wanted her kept alive. Her husband knew, but it was not recorded, I think, that she did not want to be kept alive in that circumstance. And she suffered through many, many, many years of being in a vegetative state without her wishes being fulfilled. With an advanced healthcare directive, your trusted loved ones are making the decisions. The persons that you designate who know you best are making the medical decisions for you in that time of great, great, great need. Your wishes are actually documented in the Advanced Healthcare Directive. This is a California form, and they provide a space for you to actually tell the doctors and your healthcare agents what you would want done if you entered into incapacity or a vegetative state, what your preferences are for people visiting you, what your preferences are for pain relief, all of these things. And then finally, because there's no confusion, there's no need for court intervention, which is probably the biggest reason. All right, so let's return to the Chens. Because Mark and Molly are not married, again, another problem arises in the arena of finances. He cannot access her money to pay her medical bills, and he doesn't have enough on his own to be able to do that. So what steps in? A durable power of attorney is what they would have needed. Without a durable power of attorney, you're facing the same consequences as in the absence of an advanced healthcare directive. You're facing default decision makers, again, spouse, adult children, parents. And I should also add, which is really scary, that in the state of California, in theory, anybody could apply. And that's what happened to Britney Spears. She, I'm guessing, didn't have one of these because in the California statutory form, you actually designate, in addition to someone to handle your finances in the case that you become incapacitated, you name a conservator. A conservator is the person who takes care of your finances when you're incapacitated. And in this case, she hadn't named someone explicitly, so guess what? Her parents. Her father ended up taking over her conservatorship. And a lot of disempowerment happened because of this lack of planning. And I so wish that everybody had this in order to avoid a situation when someone they're not comfortable with is making decisions for them. So yes, lots of courtroom drama with Britney that all could have been avoided. With the durable power of attorney, again, trusted loved ones are making those decisions. Nobody else can step in. You have a document that says, this is the person I want to take over if I'm not able to make financial decisions for myself. Your wishes guide, again, there's plenty of space in the durable power of attorney for you to designate specific guidelines. And there's no confusion, so there's no need for court intervention. All righty. Returning to the Chens. So this is where we're going to start talking about what happens after death. Those two items I mentioned before, the Advanced Healthcare Directive and the Durable Power of Attorney, are both documents that come into play when you are still alive but unable to make decisions. Now we're moving into the role of what happens after you die. So Mark and Molly both passed suddenly, more or less simultaneously, due to complications from their injuries. Their neighbor, Dina, who is a trusted babysitter, longtime babysitter, and has been with the kids a lot during this time when both Mark and Molly have been in the hospital, actually does not have authority to take custody of the children. There's no legal documentation for her to retain them once something happens. And in the weeks leading after Mark and Molly's death, there's a conflict around guardianship. Both Mark's brother and Alex's grandmother, who is his biological father's mother, Dan's mother, want custody, and they both seek custody in the courts of Alex. So, how do we avoid that? We avoid that with a guardianship plan. As I mentioned before, the state's default plan is not great. Without a guardianship plan, your children will be taken into police custody without legal documents naming a guardian, I should say. Children are taken into police custody, and if they're in police custody for long enough, they will actually be registered in Child Protective Services and the foster care system. Not an ideal outcome, especially not when children are grieving already, right? The other thing is you get default permanent guardians. So that is the people most closely related to the children. In the case of ex-spouses, in the case of blended families, in the case of single parenthood, often that's not an ideal situation, and you actually want to name permanent guardians and give them instructions about how you want your child raised. And again, without a guardianship plan, your family may have to go to court. As in the case of Alex, as I mentioned earlier, there are two equally related, or not equally related, I shouldn't say that. There are two members of the family seeking custody, and they are going to have to duke it out in court because there were no instructions left for the parents, by the parents. So with a guardianship plan, your children are securely taken care of by the people that you designate. And your decisions about your children's care are what are going to govern because you've provided that information to the guardians in advance. They have all the legal documentation in place, they have all of your wishes in place, and they pick up where you left off. So again, this keeps you out of court, keeps you out of conflict. Okay, so now we're getting into the reason why you came, wills and trusts. Without a will, the Chens have to go to court. And one of the unfortunate things about the process of intestate, that is dying without a will, and dying without a trust, is that minor children cannot inherit in California court. With or without a will, frankly. They are held in guardianship. Their assets are held in guardianship while they're minors. So what ends up happening is you go to court, the child's assets get put under guardianship, but again, California law is not great. Anyone can apply to be your child's guardian. Complete strangers have applied to be a child's guardian. It happens that in probate court, where all of these decisions are being made, anybody can show up. And there are looky-loos and there are bad actors who are there for predatory purposes to find the children who will inherit at 18 years old their $2 million, their $1 million, their $500,000. So let's talk about a will. A will is a document by which you designate who gets your stuff after you pass. It will, in the absence of a will, your family will go to court, period, end of story. There is no escaping probate court if you don't have a will. Now, I am going to try to illustrate the pain of probate by simplifying it down to three pillars. The three pillars of probate pain, I call them. Probate, let's start off with, is the process by which your stuff gets transferred from you as the person who's passed away to whomever would receive it. There's some contestation in the court sometimes about who receives. There's contestation about how much. There's contestation about how much there is. But all of that fun drama gets to unfold in probate court. Now, probate court is actually court. It's open to the public. And so all of that dirty laundry is getting aired in the public. All the things that I would rather keep private. In addition to which, probate in California can take up to 18 months. And that is for a standard case with very little contestation. That's a year and a half when your family will not have access to anything of yours because it's being held by the court before it can be distributed. So I don't know about you, but my family doesn't have enough to skate through 18 months without my assets. Finally, money. Probate court in California can cost you up to 5% of your total assets. And for California homeowners, I find this particularly interesting. That does not just include the equity in your home. That is the full market value of your home. So the market value of your home is determining how much your family is having to pay to a probate court in fees, attorney's fees, costs, all of those things, just to get access to the home. Good luck getting the full value out of it after all of that's been taken out. In addition to which, as I mentioned before, an inventory of assets is often what a will is I own this and I give it to that person. Without an inventory or a will to inventory that, a lot of your property is going to end up with the state in the State Department of Unclaimed Property. Oops, excuse me. Oh, yes, thank you. So Prince, I hope you all have heard with him. I met with somebody the other day who didn't know who he was, and it made me feel very, very old. In any case, Prince passed away in, I think it was 2016, with a very substantial estate. About $156 million was the total value that they finally assessed. So, question to you, how much do you think Prince paid in probate costs? It wasn't just 5%. His heirs, without a will, because he died without a will, went through 6 years of court battle. $3 million just to fight the claims of total strangers who claimed that they were his love child, his second niece, his third cousin. They had to fight all of those. In addition to which, they had to pay $31 million in taxes before they inherited a cent. And finally, he ended up paying his heirs ended up paying $45 million in legal fees in total just to get through the process. So by the time they were done, that estate was worth less than half. Yeah, not a situation you want to end up in. So going back to the will with a will, not putting yourself in that place that Prince put his heirs in, your wishes guide all the distributions. That's the primary thing, right? That's choice. In addition, I need to mention though, that you will go through probate even with a will if you fall under certain categories. If you own more than $166,000 in assets, and trust me, that adds up faster than you think. If you own real estate, any real estate of any size, it could be a lot worth $10,000. It will have to go through probate. No real estate can pass hands without going through the court system, even with a will. And finally, your minor children cannot inherit. So they're in guardianship, depending upon their age, it could be years. They're in guardianship until they're 18 years old. So you're paying attorney's fees, or a bad actor is stepping in if you don't have somebody trusted to watch them. So these are all situations that you would very much want to avoid, I'm guessing. And the way that you avoid that is with a trust. So this illustrates one of the big pain points and one of the major reasons why people want to trust their minor children. Even if they avoid guardianship in the courts, they would inherit at 18. outright, everything. I don't know any 18-year-old. I wasn't an 18-year-old and I was at Stanford. I don't know any 18-year-old that can handle inheriting at that age. And it is, I read a statistic recently that said that something like within 2 years, 1/3 of all adult beneficiaries of a will that inherit outright are in negative savings. 1/3. So better believe that that 18-year-old is in that group. All righty, so let's talk about a trust. Without a trust, your kids inherit outright. Not a great situation. There is no planning for taxes or asset protection without a trust. A trust is where you do all of this planning to minimize the taxes at your death. And finally, the big, to me, big pain point is you're going to go to court without a trust. If you own more than $166,000, if you own any real estate, or if your kids are minors. With a trust, you avoid probate entirely. This is a huge boon, a huge boon. So remember that slide I showed you earlier, where the cost of trust is $4,000, but the cost of going through probate is $37,000 on the average California home. If you could avoid that entirely, wouldn't you want to, right? So you're avoiding your family having to go through court while they're already grieving your loss. You're avoiding the tax consequences of not planning. You're setting your kids up with asset protection so they're not inheriting outright. They can learn the ropes a little bit first. All of these things are part of a trust, a well-formed trust. And to me, this is the number one vehicle by which to avoid unnecessary costs and expenses during this really difficult time. So as I mentioned, with proper planning, the Chen's children could have lifetime asset protection. They could avoid having to go to court with strangers and in a time of grief. And that's really what they would probably choose and what you would choose too. So let's get to talking about what estate planning is in the average experience. In the average experience, estate planning is you go to a lawyer, you sit with them for an hour or two. Sometimes you understand what they're saying, sometimes you don't. They devise a plan for you. And that's your transaction. That's it. You sign the documents, they hand you a binder, you walk away, you probably don't talk to them again. This leads to a lot of problems. It's inherently set up this way. You would think that it's not, that it's malpractice, but it's actually not. It is the standard way estate planning gets done. It's one and done. There's no follow-up with trust funding. Trust funding is the process by which you put all of your assets, rename them, and put them into the name of the trust. The reason for this is that when you pass, that entity continues to exist, even though you no longer do. So it's like a corporation in a way. It just changes from you being the beneficiary of your trust to somebody else being the beneficiary of a trust. And that happens in a law office. There is no court involved. It's a very simple out-of-court transaction. But that trust is worth nothing if you don't put your assets in the trust. And more often than not, estate planning lawyers do not follow up with their clients about funding their trust. And let me tell you a little story about what happened to my family when that happened. So my grandmother, she died around the turn of the century from pancreatic cancer. She was very sudden. If you know the nature of pancreatic cancer, it goes very, very quickly. And in her last days, she thought she had taken care of what she needed to take care of because she had seen an attorney about 20 years before that to take care of everything. That plan had not been updated in 20 years. As we found out later, her trust had not been funded. So when she passed, we were put in the pathway of a lot of court interactions because one of the things that happened is nobody could find her trust. The attorney who drafted it did not have a copy. No one could find it in her documents. And so we were put in the position of having to go to the court and reinstitute after her death, her wishes to the degree that we knew them in a trust. And that involved a little bit of dissension, actually, between the children who were raised by her primary beneficiary, which was her second husband, who was my grandfather as far as I knew, but a lot of the generation above me, my father and his siblings, weren't raised by this second husband. So they didn't have the emotional attachment. So when time came to reconstitute the trust, they wanted to sell the family home. And that would have put my grandfather on the street. So people like me, the grandchildren who happened to know what grandma wanted, had to intervene and say, no, that's not what grandma wanted. And we had to fight for what it is that she did want. And that is not a fun situation to have to be arguing with your parents and your aunts and your uncles when your grandmother has just died. But this is a really typical experience. Documents get lost, trusts don't get funded. A lot of things happen in the interval between when a plan is created and when the inevitable eventually happens. And a lot of times, the plan doesn't work when your family needs it the most. So let me talk now about how I do it differently. I do something called life and legacy planning, and we're a nationwide network of lawyers who practice this way. And it is specifically designed to counteract the normal systems of estate planning. The intention is to give you a trusted advisor for your whole life. As a base minimum, every 3 years, with every plan that I create, I check in every 3 years with my clients. Has anything changed? Let me understand what's changed so we can understand whether or not we need to adjust your plan. And those plan changes are incremental costs. They are not having to plan all over again, which is usually what happens in the traditional estate planning method, is you don't do anything for 10 years and you got to go in and redo the whole thing. So you're actually adding more cost to your bottom line by doing that. We focus a lot on education. As you can see from this webinar, we are all about education for wise decision making, you being the decision maker. We also either do it with you, DWI, or do it for you, DFY, trust funding. We will hold your hand or we will take it on ourselves, because that trust is worth nothing if it's not funded. Finally, we include tax and asset protection planning in there, thinking about the long term, the mid-term, the short term to maximize your tax savings. In addition, we focus a lot on digital assets and intangible assets, the kinds of things that most estate planners don't actually document. And the final thing that we do is we really focus on your legacy. We focus on giving your heirs the information that you would want to give them after you pass. We record interviews, we draft letters to your guardians to let them know how you would want your children to be raised. We put in all of that customization so that not only your assets are passed down, but your wishes, your stories, your values, your memories, all of that. It is really a process of whole wealth planning. So some of you don't need me, and I want to be very clear about that. If you fall in the category of persons having insufficient assets for a trust, that is, you have less than $166,000, you do not own a home, and you have no minor children, and you're very, very clear about who you would want filling those roles, making decisions for you, taking guardianship of your children, and you're very organized and you know you will get it done. If that is the case, please scan this QR code here. At this QR code, is a Google Drive containing statutory form documents for the state of California that will give you an advanced healthcare directive, a HIPAA release form, and a durable power of attorney. And you can just handwrite your will. In the state of California, you can do something called a holographic will, which means handwriting. So if you write it out in your hand, you can't type it, you have to write it out, sign it, and date it. That is a fully executable will in this state. So I encourage you, if you don't need to meet with me, please, please do this for yourself. If you do need to meet with me, if you fall outside of that category of persons who can do it themselves, your first question is probably, what does it cost? It's always my first question. So the first meeting with me is called a life and legacy planning session, and that's $750. But stay tuned. I'm going to tell you how to get that for free in just a minute. All right. Our estate planning packages they vary in range. There's something for everybody. The average client picks a package between $2,000 and $8,000. And rest assured that if you come in and meet with me, you will only be planning with me and only be purchasing something if the cost of working with me is less than doing nothing. So on that note, let me make it really easy for you. The whole point of my firm is to make this easy and affordable for everybody. So what I'm going to do, because you attended this webinar and you educated yourself, you empowered yourself, you got this information, I am going to give you $1,000 off my services. First, I'm going to give you, if you complete 3 requirements, I will waive the fee of that life and legacy planning session. So that's $750 off. Plus, I will give you an extra $250 towards any planning package you purchase if you, 1, book a life and legacy planning session with me in the next week. 2, complete your homework that I will send you immediately upon booking your appointment. And 3, you get that to me at least 3 days before your planning session. If you do these 3 things, you get $1,000 in free legal services. We want to make it easy and affordable. All righty. So that is the end of my presentation. We have about 5 minutes left. If any of you have questions, please feel free to write me in the chat and I will address them right now. I see one right here. Before I address that one, I'm going to say, if you have questions and don't want to put it in the chat, use this QR code to get a free consultation with me, 15-minute call, and we'll talk through your scenario and whether or not you would be best positioned by coming in to see me. And if you're ready to book right now and to cash in that golden ticket, this other QR code takes you directly to my booking site. We'll get you all signed up and we'll get you taken care of within about 4 weeks. Your plan from the date of your planning session to your plan being executed is only 4 weeks. Let's get it done. Let's get you safe. All right. So I see in here we have a question. Do you have to file a tax report every year? I'm guessing that is a question for post-death trust administration, and please correct me if I'm not receiving that question correctly. The answer to that question is there are 2 types of trusts. One is a revocable trust, which is a trust in which 3 positions are held by the same person: the trustee, who is the person who disperses the money, the beneficiary, who is the one who receives the money, and the grantor, who is the one who gives the money. If they are all the same person, meaning you, then no, you do not have to file a tax return every year. It's a little bit like owning a sole proprietorship, where all of that income passes through to you and it's considered the same. So you are reporting your taxes to the IRS. It's all that stuff that's sitting in your trust is considered owned by you during your lifetime. After your death, that trust is no longer revocable because you're not there, right? So it's irrevocable, meaning the terms of the trust cannot be changed, okay? Those trusts do need to file a tax return every year. if they receive, oh, actually, you do need to file a tax return every year, but you won't have to pay taxes if you pay out all of the income to that trust. If you send that out to your beneficiaries, there is no income to the trust. So you're filing a tax return for zero income. It's a pain, but it's also incredible asset protection for your heirs. It keeps them away from, it keeps all of that assets in your irrevocable trust away from their creditors, their spouses, their ex-spouses, people who sue them, all of that. Okay, I hope that that is the answer to your question. And I see that the QR code isn't working, and I'm so sorry for that. So what I'm going to do is I'm going to go ahead and I'm going to plop some links into the chat. The first one is for the free resources. Okay, the second one, and bear with me just a moment while I call this up on my screen, is my Square appointments calendar, wherein you can book a life and legacy planning session. And the third I'm going to put up is my booking website for a free 15-minute meeting. Oh, I'm sorry. I see I'm doing this just to everybody. For a free 15-minute meeting wherein we will discuss whether or not I can help you more than you can help yourself. Okay, let me just get this in here. Are there any other questions that I can address before I close this out? Please feel free to send your questions my way via the chat. And if you're having any trouble with the links or the QR codes do seem to be having a problem. So the links in the website, the links in the chat will get you to each of those individual pieces that I mentioned. All righty. So I'm going to assume that there's no other questions, or that if you do have questions, you will book an appointment to come talk to me. I am happy to answer any of those questions. It was so lovely meeting with all of you today. I really do wish you health and wellness and peace of mind. I hope this gave you peace of mind. Take very good care of yourselves, and I will keep you updated about upcoming webinars. Have a wonderful day.